So what I want to suggest that you might want to try, this is for the Lincoln Douglas debate topic for NCFCA about due process and discovery of facts. And what I've seen is that there are a lot of people who are sort of bemoaning the fact that you can't put discovery and facts together and come up with anything that's really a legal procedure that would operate in a way that you can pose it up against due process. It's very hard to find a way to characterize it as being in conflict, in other words. And I've been digging around, and I never went to law school, I've never been an attorney. All I've done is what a debate coach does over the years. You read up enough about how the legal system works that you can make arguments about it, and half of my former students went on to law school, and some of them they'll explain to me if I ask them some of the finer points of some of these legal matters. But something that I think you might look into is discovery abuse. Now, discovery is the whole period before the trial where the two sides exchange information governed by certain rules. And where I would look if I were you is I would look at requests for admissions, because the language that's couched in requests for admissions, that's where you ask the other side to stipulate something just so you don't have to bring evidence into court to prove it. So you might do a request for admission that the sky is blue. You're not going to make us really bring an expert witness into court to testify under oath the sky is blue so they can be cross-examined, right? Well, there are certain circumstances in which there are lots and lots of requests for admissions. There are several states that put a limit on how many requests for admissions that you can actually carry out, that you can actually send to the other side, and there are sometimes sanctions when people abuse it and use discovery tactics in general and requests for admission in particular to try to overload the other side and hassle them, to harass them to where they are tempted to enter into settlement negotiations, slightly more willing to try to make all this litigation go away. So what I think you could do is I think that you could look into that, and the sanctioning of it is where due process would come in, because for due process to be a question, there has to be government action. You can only be denied due process by someone who's a government actor. So I think that what you would want to look for is one of the states where they have not done a good job with their sanctioning, either where requests for admission have run amok and they are still being used in a very illicit and sort of game-playing fashion to harass opponents in litigation, or you might want to look for places where the sanctions are actually too harsh, where you're limited to a very small number of requests for admission, and then find the arguments that people make, and there are actually plenty of them. There was a real good article talking about how requests for admission in Wisconsin, according to Wisconsin's rules, are actually underutilized because attorneys are so afraid of not getting a timely answer and getting into sort of an arms race of sending these sorts of things back and forth. But I think if you could talk about sanctioning for discovery abuse, that's the kind of thing that with a little brief explanation you can help a judge understand fairly easily, and that might be a way into the topic that helps you talk about discovery of fact, but also talk about how it matches up with due process without having to concoct definitions that are really just patched together out of debaters' sort of loose impression of what the topic should mean. So have a look at that and see what its prospects are for putting together a good strategic case on your topic.